Hi everyone, welcome to topic 5. For today's lesson, we'll be covering on the topic of judges and lay magistrates. So there are differences between judges and lay magistrates. So this lesson will be uncover about the differences between these two roles, and we'll also learn about many other interesting things about role of judges apart from interpreting the law. So for today's learning outcomes, we learn about the judicial hierarchy in terms of the specific designation of the judges who sits in Supreme Court, Court of Appeal and the rest. We'll also learn about the constitutional role of the judiciary. We also learn a bit on the separation of powers and how the role of the Lord Chancellor actually does not provide for separation of powers. Because of that, the Parliament introduced Constitutional Reform Act 2005. So the CRA 2005 actually revamped the whole thing with regards to the appointment of judges in order to address the criticism with regards to the judiciary. So we'll also look into the reforms of the judiciary, and lastly, we'll cover the parts on lay magistrates. So whether or not they are truly a judge or not a judge. So let's look at the introduction first. And the picture here that you see on the screen is actually a judge in UK. In UK, the judge will wear a wig and also a robe. So they have a very unique attire when they hold a position as a judge. So as all of you already know, the primary role of a judge is to resolve dispute. So judges will exercise their special function in order to resolve dispute between the parties by looking at the law, facts, as well as evidence. So by using the relevant law, judges will interpret it and apply it based on the facts that they have at hand. So the role of judges applies similarly to criminal cases, civil cases, as well as appeal cases. Of course, when it comes to civil cases, a judge needs to listen to the whatever has happened, and after that find the relevant law and provide the relevant sentencing. For civil cases, there are no sentencing, but judges will hear about the claimant's claim and look at the facts and the relevant laws and provide awards to the parties. When it comes to appeal cases, judges no longer listen to the facts of the case because the judge at the lower court has already looked at the entire facts of the case. So at appeal level, judges will only look at the application of the law. So whether or not the judges at the lower courts have actually applied the law correctly, or whenever there's ambiguity, so the courts at the appeal level will look at it in a different way. So it is very important for you to understand the role of the judges apart from interpreting the law or resolving dispute. Because when you hold position as a judge, you actually hold a much bigger position in terms of your power as a judge. So let's look at the judicial hierarchy. So judge, when they sit at the different hierarchy, they are known by different name. So lay person will call a judge, regardless if a judge sits in a high court, court of appeal, or Supreme Court. But as a lawyer, you need to know the designation of each judge so that you know when someone say, oh, he's a recorder. So you know he's from which level of court. So on the slides, as you can see, I've separated into two sections. So you have superior judges. You also have inferior judges. So superior judges are those judges that sit in the superior level, basically means high court and above. So if you have judges that sits in a high court, you call them high court judges. If you have judges that sits in a court of appeal, they are known as Lord Justices of Appeal. And if you have judges that sits in the Supreme Court, they are known as Justices of Supreme Court. So that's pretty clear. But when it comes to the inferior judges, that's where students find it a bit difficult to remembering the name and also where exactly they stand. So let's look at the first one. So you have circuit judges. So circuit judges are actually judges that sits in the Crown Court or County Court. So in order for you to be appointed to be a circuit judge, you need to actually practice as a barrister first and need to have a standing at least 10 years. So then you'll be wondering, what is recorder? So the number 2, recorder are known as the part-time judges who are usually sits in the Crown Court that listens to criminal cases. So even though they are part-time judges, they are also need to have experience working as a barrister for 10 years. So you also have district judges. District judges, most people will compare it with lay magistrates. So district judges, in one hand, are usually legally trained. They are paid, and they also sit at magistrate courts level. Because they are legally trained, so they need to have an experience as a barrister, at least 7 years standing. So when we talk about lay magistrates, they are also known as justices of peace. So that's the last bullet point there. So lay magistrate here are those who sit as a magistrate judge, but who do not acquire any legal training, do not even have a Bachelor of Law degree, work voluntarily without any pay. Interesting, isn't it? So we look at the section of lay magistrate at the end of the session. So as you all know, the role of judges to interpret the law, resolve dispute, but then let me ask you this question. Where can you find the role of judges, and in terms of the hierarchy? Who sets the hierarchy? So where can you find this template? So that's right, you guessed it, because in UK, there is no written constitution. So because of its unwritten nature, you need to look at common law cases. So even academicians have wrote about it, so many people have talked about it. So let's look at the father of the Constitution, Montesquieu. When he talks about the role of the judiciary, he reminds everyone with regards to the perfect model of the governance of a state. So in order for you to have a good model, you need to have 3 branches of powers which are separated. For example, legislative, executive, and also judiciary. So if you mix up this role, it can be hazardous, because if you have one person that has power as a legislator, executive, and judiciary, public will raise eyebrows saying that there could be conflict of interest. So this is one of the famous dilemma faced by the British. It has been highlighted in UK, the role of Lord Chancellor. It can be, it's not confusing, but the role of Lord Chancellor can be quite dangerous, because as the Lord Chancellor in UK, previously he sits in the legislature, executive, as well as judiciary. So it's one clear example how British Constitution did not adhere or did not follow the perfect model of a state described by Montesquieu. So let's look at the separation of powers and also the role of Lord Chancellor. So in UK, back then, you have one person, his name is Lord Chancellor, who sits in the executive as a member of government, who is a head of judiciary, and also member of legislature. So he has power here, here, and here. So because you have one position but sits in all branches of government, it raises concern. But you have to understand, the role of Lord Chancellor has been in existence for hundreds of years. So when you have hundreds of years kind of position, you have hundreds of years types of responsibilities, paperwork. So all of this becomes an issue, because if you want to eliminate the role of Lord Chancellor, then who's going to do the paperwork? If you're going to appoint someone new, what are you going to call him or her? So this was raised back in 200 years ago, but because of a lot of issue raised, some say you want to maintain the tradition, some say it's modern states, you need to change the role. So finally, in 2013, this issue was addressed in the parliament, and actually the government proposed the abolition of the office of the Lord Chancellor. So they want to show that they they appreciate the idea of Montesquieu to have a perfect model of governance by separating the branches of legislature, executive, and judiciary. So in 2005, Constitutional Reform Act was introduced, and CRA 2005 brought significant change with regards to the role of Lord Chancellor. So Lord Chancellor now is no longer head of judiciary, is now the Secretary of the State, and like other cabinet minister, also member of legislature. So this is one example where you have one person who sits as a Lord Chancellor who holds three positions. His name is Lord Irvine. Lord Irvine is a Scottish lawyer, judge, and political figure, and it's very interesting because because previously one of his pupil barrister was actually the Prime Minister Tony Blair. So after his appointment, after Tony Blair's appointment in 1998, Lord Chancellor's office residence, basically Lord Irvine's new office, new residence, was redecorated at the cost of £650,000. So as you can see, when he holds his power as a Lord Chancellor, there's some sort of abuse of powers, because the moment that he steps into his official residence, he starts decorating it, but not using his own money, but he's using taxpayers' money. Then he raised another controversy. There's another issue with regards to him, is when he organized a party, who were known as Labour Party sympathizers. So he organized a party, get people to come and donate at least £200, whoever attend to his party. So it's not good in the eyes of the public. You have a person who sits as a judge, a member of executive legislature, organizing a party in the first place. And if you want to come to the party, you need to pay at least £200. So that party, if you Google it, is known as the Cash for Weeks affair. So, so there was another dispute about him. And then in 2003, there was another controversy. It's because he sits as a member of cabinet. He was awarded a pay rise in terms of his salary. So to the extent whereby he is getting paid more than the Lord Chief Justice. So after a lot of people were talking about it, it came out in the news, public was not happy, so he decided that he will accept a modest increase in terms of his salary. But that's not all there. There are so many issues with regards to his role when he sits as the Lord Chancellor. So finally, in 2003, Lord Irvine was actually sacked by the Prime Minister in 2003. So that's actually a clear example of how one person who sits in the executive, legislature, and judiciary have abuse of power, of conflict of interest as well. So when Lord Irvine was sacked in 2003, so you have Lord Falconer, like in the picture on the slides, was appointed as his successor. So at that time of his appointment, it was announced that the role of Lord Chancellor will be abolished. So the role of Lord Chancellor was partially reformed under the Constitutional Reform Act. So now there is a new title called the Secretary of State for Justice to replace the role of Lord Chancellor. But the thing is, then who's going to take over the tasks and responsibilities done by the Lord Chancellor in the past? So Lord Falconer had to do it because he was appointed to replace Lord Irvine. So essentially, when we talk about reforming the post of Lord Chancellor, he's actually doing the job of Lord Chancellor altogether. So it's a bit confusing in that sense. So that's why we're coming out to the next slide. We want to have a look in greater detail with regards to the reforms of the judiciary. So where can we find this reform? It's under the Constitutional Reform Act 2005. So this act actually deals greatly in order to emphasize on the independence of judiciary, that judiciary needs to act neutral and without having any advice or perspective from other departments, need to be not biased. So CRA also talks about reforming the role of Lord Chancellor to replace House of Lords with Supreme Court, and also reform the system with regards to judicial appointments, so how judges are appointed in the first place. So these changes are quite significant because they had important practical consequences, because it concerns the day-to-day activities. So we look into the next slides with regards to the appointment of judiciary. Before Constitutional Reform Act, so how judges are appointed is basically on the by way of invitation. So Lord Chancellor will invite whoever's interested, but he will select certain people. So it was made secretly, so there was no transparency in terms of the guidelines of who can become a judge, who can become a High Court judge, who can become Lord Justices of Appeal, and so on and so forth. So once he has received the invitation, so what he'll do is that he himself will advise the Prime Minister on the suitable candidates. So then the Prime Minister will then decide according to the advice given by the Lord Chancellor. So this has raised issue because of there's no transparency. So judges appointed are not based on their merits. Essentially, it means that they are not appointed based on their experience. So they are appointed could be because he's a friend of the Lord Chancellor, appointed could be because a relative, appointed because he's good looking. There are no clear guidelines or criteria. So it was perceived to be very dangerous and not fair. So when Constitutional Law Reform Act was introduced, they have set a proper procedure. So they have established the Judicial Appointments Commission, JAC. So JAC is responsible for the proper recruitment and selection of judges. So if you want to get promoted, so this is what you need to do. So there is a very clear and transparent guidelines. So appointment process also increase ethnic composition so that it will not only be white and male judges, it will also include female judges as well, Asian judges as well, other ethnicity as well. So in order to be fair. So there's an article written by K. Mallison, talks about the appointments, Judicial Appointments Commission. It says that by having this commission, it actually strengthened the quality of appointment because you are appointed based on a proper process. So this will promote transparency, promotes diversity because from different race, and because of this clear criteria, it increased the public confidence with regards to the appointment system. So let's look one by one at the changes brought by the Constitutional Reform Act 2005. So the first one, like I mentioned earlier, with regards to the role of Lord Chancellor, he's no longer the head of the judiciary. So he has no power to appoint judges. So he sits as the members of the cabinet and also members of the parliament. So who now is the head of the judiciary? So Constitutional Reform Act provided that provision. Lord Chief Justice of England and Wales is now known as the head of judiciary of England and Wales. So Lord Chief Justice is responsible to provide training, guidance, and deployment of judges in order to improve the perception of the judiciary in UK. So whenever there's new ideas, so Lord Chief Justice is the one in charge of it. The third one is with regards to the establishment of Supreme Court. So it replaced the House of Lords. So they have their own building, their own staff, their own budget. So there is no conflict of interest between House of Lords that sits in the Parliament and House of Lords being the highest courts in UK. And lastly is the Judicial Appointments Commission. So this is the significant change brought by Constitutional Reform Act, whereby the commission is responsible in selecting candidates to hold a position as a judge. When it comes to judicial appointments, So this is what JAC has set up. So the number one criteria for appointment is that it must be based on merit, must be based on their experience. So it can't just be because I'm relative to this, I'm a friend to this. So I know this person, I know that person. So based on his experience, so how many cases that he has said, so how many decisions he has made, how many judgment he has written, so then he can submit his recommend application. Then it must be recommended by the commission itself, JAC. So JAC will then consult the Lord Chief Justice, who is the head of judiciary, before recommending a judge for an official appointment. So when Lord Chancellor receives the nomination from the JAC, so Lord Chancellor can either confirm the candidate, reject the candidate, or ask the commission to reconsider. So then finally, if the Lord Chancellor is happy with the decision, approves it, then the candidate will get appointed by the Lord Chancellor or by the Queen. So when it comes to Supreme Court judges are selected by Supreme Court Selection Commission. They have a special commission body, and this selection will report directly to the Lord Chancellor. So who sits in JAC, in the Judicial Appointment Commission? So when you establish this commission, it can't be all judge, because then all of them know each other. So there will be again conflict of interest. I know this, I know that, he's my friend, he's my nephew. In order to be fair, so the composition varies in terms of their experience. So it shall consist of 15 commissioners, and it consists of lay members. It consists of members of the judiciary, those who works in the legal profession. You have one tribunal member, you also have one magistrate. So each of these members, they have different experiences, so they can provide different perspectives when selecting a judge for promotion or selecting a new person to become a judge. So the selection procedures, there are only 3 steps. So vacancy are advertised. It's no longer made secretly. So any person that's interested can make an application. There will be an interview, and depending on how successful it's interviewed, together with their resume written, experience written in the resume, then JAC will shortlist the candidates. So once everything has been shortlisted, then they can recommend it to the Lord Chancellor for final approval. So it's very simple step. So it's much better than the previous appointment system, where nobody knows when can apply, who's entitled to apply, and chances of application. So as a judge, if you're appointed to deliberate on cases, it's very important for you to act impartially, which means you need to be fair, you need to be neutral, and you cannot be favoring any other party. So in some circumstances, if judges cannot help themselves but to be biased, then parties can make complaint. So then there will be a disciplinary board hearing the complaints and decide accordingly. So this shows that judges are not above the law. So if there is a misconduct, actions can be taken against these judges. So with regards to judicial conduct and discipline, it's also stated in the Constitutional Reform Act 2005. So it sets the official or formal disciplinary procedures for judges who have behaved unbecoming of a judge. When it comes to district judges, recorders, circuit judges, they can be dismissed by Lord Chancellors, either by reason of incapacity, which means sometimes if they get heart attack, they can't continue to work, or they suffer from stroke, so which hinder them performing a day-to-day task, or misbehavior, then they can dismiss by Lord Chancellor as indicated in the CRA 2005. What about High Court judges, Lord Justices of Appeal, and Supreme Court Justice? So the judges that sit in the superior courts can be removed once they have approved the decision by both houses of parliament. So for superior judges, they can be dismissed by both houses of parliament whereas the one that sits in inferior court can be dismissed by the Lord Chancellor. So there have been a very limited number of circumstances whereby judges have been dismissed. So this has happened way back in 1830, where one judge was removed because of misappropriating of funds. There are also circumstances where a judge who is actually a Scottish judge, was removed because he was smuggling spirits, alcohol, and tobacco in his yard. So when he got caught, so there was a disciplinary hearing and then subsequently dismissed because he was acting like not a judge. So as you can see, because judges can also be prosecuted, it shows that judges are not above the law. So then one will think that if I'm not immune from the law, should I take up a role as a judge? So hence coming to this subtopic with regards to judicial immunity. So whether or not judges can be sued or can be prosecuted, or they are immune entirely. So as mentioned earlier, judges are not immune if they have breached a law. So they are just like any other normal citizens. Action can be taken against them. But with regards to this slides or this subtopic, when we talk about judicial immunity, essentially it concerns whether or not parties of the cases, like party A, party B, not happy with the awards or not happy with the sentencing, can sue the judge. So because of that, judges are actually immune from parties taking action against them, because they are only doing their jobs. They are interpreting the law as they deem fit and subsequently providing the decision based on the evidence and facts presented. So if parties are not happy with the decision, they can't sue the judge. Judges are immune in that way. Okay, hopefully all of you understand with regards to the hierarchy of courts, the role of Lord Chancellor, how it has been reformed by the Constitutional Reform Act, and then there is a new appointment system. So let's look at this quote with regards to the criticism of the judiciary. So it states here, the youngster believe that we come from a narrow background and it's all nonsense. So this quotation is actually mentioned by Lord Denning in this book, Anthony Sampson, The Changing Anatomy of Britain. So whether or not this quotation is true or not true, it's because of there are many criticisms since many years ago. So hence, it's very important for you to understand the role of judiciary, the criticism with regards to the judiciary, and what you can do as a future lawyer or future judge in order to polish the image of the judiciary. So number one criticism with regards to the judiciary is because majority of judges appointed tend to be white, tend to be male, tend to be middle and upper class, and tend to come from graduated from Oxford or Cambridge University, which means anyone who does not fall under this category will not be appointed as a judge. So because of that, there is the criticisms that when you appoint male, white from upper class, they are not representing the society. They're representing white, male, upper class family. So because of that, they don't want the public to have lower confidence in the judicial system, because as a judge, regardless of your race, ethnicity, background, you are deciding the case based on the evidence and facts presented. So you are deciding fairly and impartially. But so happen that they were appointed white, male, and from upper caste family. So because of that, many people not happy, even though it's coincidental. So in 2004, research was conducted with regards to the appointment of judges, and it said majority of them fits the category that everyone's not happy with: male, white, upper class family, from Oxford, from Cambridge. So not many women judges, not many black judges, not many Asian judges or other minority ethnicity. So because of that, they say what happens if you have a minority that committed a crime, not necessarily responsible, but you fear that the judge who is white from rich family gonna give decision not in favor of this person, for example. So many research was done, and over the years they have tried to improve the appointment of judges. So they have to ensure that there is a good balance in terms of the ethnicity and background of the judges as well. So as you can see, I've extracted this information from the government website with regards to Judicial Diversity Statistics 2019. So the key finding is that 32% of court judges and 46% of tribunal judges were women. So there have been increased number from 2014 to 2019, from 24% up to 32% with regards to the court judges who were women. So at the second point, BAME stands for Black, Asian, Minority, Ethnic. So 7% of court judges, 11% of tribunal judges, and 70% non-legal members of tribunals were Black, Asian, minority ethnicity. So as you can see that there's an increase of 2% in each group from 2014 to 2019. So it's a good thing. So there have been increased in terms of diversity when it comes to appointment. So there was also concerns with regards to the background of the judges. Most of them are all barristers. So previously, in order for you to be appointed as a judge, you need to have a barrister of a 10 years standing or 7 years standing. So now they also include, if you're not a barrister, but you practice as a solicitor, there are also chances of you to become a judge. So at point number 3, you can see that 33 of court judges and 63% of tribunal judges were from non-barrister backgrounds. So this means that solicitors can also be appointed as a judge. And then the rest, more than half of magistrates were women. So it's a good statistics which indicates the increased numbers of diversity with regards to judicial appointment in UK as of 2019. So this is the statistics with regards to women in judiciary. As you can see, good number of increase with regards to court judges and also magistrate, 32% and 56%. This is the representation of Black, minority, ethnic, and Asian, so which holds various positions. So they are not only limited as lay magistrate or district judges or just recorders. So they also holds a different designation at different level. So these are the appointment of judges whose profession is non-barrister. So now you also have non-barristers that sits in the Court of Appeal level as well. So as you can see, there are varieties. So there have been an improved perception, enhanced confidence of the public with regards to the representation of the judges that sits in the judiciary.